and welcome to today's segment of The Power of Money. I'm your host, Michelle Graves, affectionately known for the last 3 decades throughout the United States as the Money Lady. And you as viewers, faithful viewers over the years, know that I'm deeply committed to providing you with cutting-edge information in the area of finances, insurance, real estate, things that will help you to prepare for retirement and beyond. And included in that information flow today, I have as my guest for the next hour, Nancy Roberson, attorney at law, who is one of our state of Ohio's top estate planning attorneys. She has an awesome story herself, having been a widow, having experienced the trauma of the loss of her beloved spouse. And she has been able to catapult that experience into the world of estate work, providing valuable information and assistance to clients as well as people that happen to hear her to speak. So she'll be my guest for the next hour. Please have a seat. If you don't have your estate planning work in order, you definitely want to stay put. Statistics say that the majority of Americans do not have their act together. But I'm here to tell you that today we are honored to have a woman who does this every day, and she does it with tremendous, tremendous grace. How are you today?
I'm wonderful, Michelle, and you?
Glad to have you
I'm
back.
so happy to be here.
It's been a bit. It's been a bit.
Yes.
But so would you bring our viewers up to date in terms of your background and how you wound up in this industry?
I felt called to go to law school many years before I actually got to go.
Okay.
And found that I enjoyed the estate planning track of courses in law school.
Okay.
And once I got out of law school, I made the acquaintance of several financial services people who referred some cases to me, and I started doing wills and trusts and estate planning and found that I enjoyed it very much, and then was asked to speak about that subject and found that I enjoyed that very much and incorporated my personal story into that. Eventually became a certified specialist by the Ohio State Bar Association in the areas of estate planning, probate, and trust law. And so I practiced for about 30 years and am part of what we call a boutique firm that just does estate planning and probate and trust law and estate administrations and that sort of thing.
Interesting. So what is your story? I know that you lost your spouse and it changed your life.
Yes. David was 28 when he died. He had Hodgkin's lymphoma and he died during his chemotherapy of pneumonia. Oh. And I was 27 and our daughter Amy was 2. And I was not a lawyer then. And so I started law school a year later.
Okay. Was the circumstances of his death responsible perhaps for your making that decision?
Yes. Yes, it was. Although at the time, I can't say that this area of law was a clear vision of mine. I just knew that I was supposed to go to law school and make something in my life to provide for myself and my daughter.
Absolutely. That had to have been very, very difficult.
It was.
I'm sure it was.
It was. But I'm a person who's on mission. And purpose.
Yes, yes.
And I have found that practicing law, and especially estate planning and probate, has been my mission and purpose.
One that you have done excellently, I might add.
Thank you.
Really. So let me just shift for a minute, and because you are a boutique firm and you specialize exclusively in estate work, what are some of the things that, as you've been in practice for so many years, that are common to people when they come into your firm?
Probably the first thing is that people have a general idea that they need a will, but beyond that, they really don't have comprehension of the extent of the type of planning that's necessary to cover the basis for their lives. For example, a few people know that they need powers of attorney or health care directives. Some people know that there's this thing out there called an estate tax that they might need to plan for. Some people, especially if there's been a diagnosis on the elder law side of things, some people have an idea that there might be different kind of planning that would need to be done, especially for a married couple. If there's a terrible diagnosis of dementia or Alzheimer's, Parkinson's, that sort of thing. But in general, people know that they need wills, but they really don't know the extent of what their planning needs to include. And so it's not uncommon for people to call our office and talk to our administrative assistants and say that, you know, they want to schedule an appointment for a will, and they are told by our administrative staff, we don't do just wills. And for a few people who say, well, that's absolutely all that I want, I don't want any go any farther than that, and we'll say, we're sorry, but we really can't help you, because we feel a moral as well as a legal obligation to expose people to everything that they need.
Well, that brings up an interesting point, and that is that when a person, and let's just be open here, a tremendous number of people do not even believe they need a will.
That's
I've had
right.
this said to me so many times over the years, which is, I don't have anything. So why do I need to pay someone to tell me what I don't have? What would your response be to that?
Well, my first response is you don't know what you don't know. And most of us don't know what we don't know.
Correct.
I've done speaking in schools, high school consumer economics classes, and I'll say, if you've got a car and a boombox and a wallet with some cash in it, you have an estate plan for which you need to prepare. And even if your assets are insignificant by your judgment, you still need documents such as powers of attorney, financial powers of attorney, healthcare powers of attorney, to enable decision making to be made for you if you cannot make it for yourself. But Michelle, I'm remembering, and I got into a little argument with a client years ago, a good 20 years ago. She and her children knew that adding beneficiary designations to assets and adding names to assets as joint tenants with rights to survivorship would avoid probate.
Correct.
And they also knew that the will only directs assets that are probate assets. So this lady had supposedly all of her assets either owned jointly with her daughters or beneficiary designation. And I was called in to do a power of attorney for her, so of course I inquired about a will. No, don't need a will, and she would not do a will, period, would not do a will. Period, and died without a will.
Oh.
After she died, unfortunately, one of the CDs that had her daughters' names on them as beneficiaries had been rolled over by local significant bank, and when it was rolled over, the bank dropped the beneficiary designations. Not uncommon.
Because it's a new
CD. And so, of course, the children were furious. They took this up with the bank. The bank basically said, too bad, so sad. You know, you're going to have to probate this
You're going to have to probate it.
And that's what we did. And since she died without a will, then she had an intestate estate, and so bond had to be purchased to protect the estate, and there were additional expenses and paperwork. And see, you know, these people thought that they had everything in order, but that was a situation where that they couldn't anticipate with the bank rolling over the CD. And that's not the first time that I've encountered that in my practice.
Well, it is very common in the banking industry at the point that the CD matures and they give you notice, and they do give you notice.
Yes.
And you do not respond, then they are going to roll it over.
Yes.
And it is a new CD. And everything prior to would be null and void.
So that's an illustration.
That's a great illustration.
Probate has to be undertaken when there are assets in a person's name that are not owned jointly, that don't have a beneficiary designation, or are not subject to a statutory exemption, like for married people, certain types of vehicles. So if there's an account in a person's name only, that's going to have to be probated when they die.
And unfortunately,
that's why they need a will.
That's exactly right. And I hope you viewers are listening closely to what she's saying, because many of us do not see the value of that instrument. And I'm here to tell you, it's not what you know and it's not what you don't know, but it's what you thought you knew that's going to just be brutal. It is brutal. Am I correct?
Yes, absolutely. And the fact is that the law is changing all the time.
Yes.
That drives people crazy. It drives me crazy. I went to a seminar last month and learned there's an omnibus probate bill that's pending in the Ohio legislature. It's probably going to be passed early next year. There are a number of changes in the law that affect our lives in the areas of death and disability. So we will need to address them with people as we meet with them and help them to plan their estates.
Let's talk about, as we look today at where, as people prepare for retirement and moving forward, the bulk of assets today are still in the home. The home is still the largest source of asset, and yet the type of home and who owns it, who it's titled to. Would you clear up a common misunderstanding amongst people that as long as a mortgage is against the home, who has rights upon death? I have to ask the question because it's out here every day.
Yes, it is. People believe that when their loved ones die and the will says that they are the beneficiaries of the estate, they should receive that property. However, if there's a mortgage on it, that property is going to, the mortgage is going to need to be dealt with.
Yeah.
And so, and the mortgage is a liability of the estate.
That has to be paid.
That has to be paid.
Yeah. I just had a situation and I was very frustrated and should have perhaps walked away, but a gentleman friend of mine, an elderly gentleman, died unexpectedly, and he had a mortgage against his home. His daughter had lived in the home rent-free for years. And the bank, upon notification of his demise, wanted the loan paid off. And the daughter did not want to pay the loan off because she said, why should I have to pay the loan off? This house, I was on the house, and why should I have to pay? And I said to her, because if you do not pay, they will foreclose.
Yes.
That will be the outcome. And this dragged on for almost 8 months until it finally occurred to her that what I had said to her was true. And I shared with her, I said, no disrespect meant or intended, but if there is a mortgage against the real estate, it becomes a liability.
Yes.
You cannot walk away from that liability.
Right.
It has to be paid for.
Right.
And she was incensed, but ultimately she had to pay off the debt.
Certainly.
And she couldn't believe the bank would be so insensitive. And then she argued the point that he had insurance on the home, which he did not. And so I only bring this to the table because here again is why people need to not make assumptions
Yes.
about the areas of money and law,
Yes.
but they need to retain the services of a person such as yourself. It'll save them lots of sorrow.
And Michelle, there are so many misconceptions out there. You know, I've practiced long enough now that I have neighbors who are clients.
Yes.
And so I could always tell when there's been a coffee clutch, because one of them will call and say, well, Sally told me you did thus and such for her, and why didn't you do this for me? And of course, it's protected by the attorney-client privilege,
Exactly.
so I can't talk about what I did for Sally. But everybody's situation is different, and that's why I want to be so forward as to say that I don't approve of the software programs that are being promoted and advertised.
Yeah.
You know, do-it-yourself
Yeah.
type programs.
Right.
It used to be I would go into a drugstore where I'd get my prescriptions filled, and the legal forms were right by the drug counter. It was kind of daunting. You know, there was the will form right there.
Yes, yes,
but,
yes.
you know, those forms might do in an emergency situation. I mean, I'm talking somebody's one day has been told they need a triple bypass and they're going to have the surgery the next day and they can't get into a law office. But in general, those types of do-it-yourself programs don't apply to everyone. They just don't. I've never written 2 estate plans that are alike. Never.
Well,
in
I would
30
have
years.
to. I would have to totally agree with you. And in fact, I had a rather terse dialogue with another insurance advisor who recommended on the air that people, as long as you get it witnessed and notarized, you're okay, and to order these, to get them off of internet. And after the show, I said to that individual, you cannot ever, as a professional, recommend something like that. I said, let them do what is right and go to a specialist and have it done properly. I said, there is no, well, they don't need all that. I said, but are you an attorney?
And how do you know that?
And how
what
do
they
you
don't
know that?
Have you explored their family relations to determine whether there might be a special needs child in that family
Exactly.
who needs a special needs trust to protect her or his assets from her or his needs-based benefits? You know, that would be perhaps cut off by an inheritance.
Right.
Those are the kinds of issues that we explore when we meet with people.
Well, I think it's so important because of the misinformation and simply bad information that is out here today. Now, I've had this said to me, and I know you have as well. Many people are afraid because of the costs involved. I mean, they can spend money on other things, but the thought of paying you can be daunting. What is your response to that?
Well, when people contact our office for services, we send a packet of information that includes an estimate of our fees.
Okay.
For the different types of estate plans for single people and married people. And we charge hourly for our services, and we realize that not everyone can afford us. At the same time, we offer to take payment plans. I have bartered for services over my life.
I believe it.
I bartered for my daughter's wedding dress.
Okay, that works.
You know, that works.
That works.
And so, you know, there are ways to provide. Also, we advertised this summer in our email newsletter a college student special. A very simple will, power of attorney, healthcare directives for a very modest price. And we had clients who have been clients a long time and have grown to appreciate the value of planning. They signed their college students up for that.
Good,
you know.
good. Because things happen at any age.
They do. In fact, the nationally known cases for end-of-life decision-making dealt with younger women. You know, the tube feeding cases were younger women.
Where no one could ever say that it would happen to them.
Right.
But it can, and it does.
Well, I was 27.
Oh.
Nobody was more dumbfounded than me when I saw the heart monitor go flat and realized that David had died. I said, this, I can't believe this just happened to me.
Yes, yes. And death is so permanent.
It is.
You cannot look back.
Right.
It is so final. I
Yes,
know
it
myself as I've grown older, and seen two of my best friends die. One was an attorney and one was a international trainer. Both women, brilliant, capable women. And sadly, my best friend that was an attorney did not have a will.
Oh gosh.
In Maryland. She did not, and I labored with her because she had lung cancer, had never smoked a day in her life. And she said I was to be her executrix and blah, blah. And I said to her, I know you have this all in writing because that's what you're trained to do. And oh yes, Michelle, it's all done. Her estate was almost $3 million. She had no will.
Oh no.
She had written down our conversations, but she did not ever execute that document, which just tells me that people must be in a state of denial.
They are. They are.
Okay.
Death is, you know, I tell people, and I remember when the first Star Trek came on.
Okay.
You know, space, the final frontier.
Yes.
And I said, no, space isn't the final frontier. Death is, and we're all afraid of it.
This is true, but it is inevitable as the air we breathe.
Yes, it is.
It is.
And you know, when you said that she had her wishes written down, we've experienced that a number of times in our office, unfortunately, with suicides, where people write their own will before they commit suicide, and they go have their signature notarized.
Okay.
Well, in Ohio, Ohio requires 2 witnesses to a will. So a notary isn't enough.
Right.
Not enough. That's the same. So if a person dies with an invalid will, that's the same as dying without a will.
Correct.
And that's kind of a double heartbreak for families who have experienced their loved one's suicide.
So, and I didn't know this, a person has to have, if they choose to do this, they still have to have 2 witnesses outside of the notary.
You don't, actually, Michelle, a will does not have to be notarized in Ohio.
See?
Yeah, you don't need to have a notary in Ohio for a will, but you need to have 2 witnesses. Now, the witnesses should not be related to the testator, the person who did the will, or be a beneficiary in the will, because the Ohio Revised Code says that if a beneficiary witnesses the will, the beneficiary loses the benefits under the will.
My goodness.
Yeah.
Now you see, that's worth a trip to your office right there.
Yeah.
That is.
So there are all these little technicalities that are in the law for a reason, to protect people. And that's what we lawyers know that lay people don't know.
And you know what? And that is actually as it should be, because the laws are written by lawyers. They're not written by lay persons. And I know that even myself, there's just so many areas in this whole issue of estate planning that are just always emerging. And they vary state by state. What goes in Ohio does not go in Kentucky or Indiana.
Absolutely.
It's just all over the place.
Yes, yes. For your listeners who are not Ohio residents, they need to be very careful and go to an attorney in the estate who is licensed in the estate of their residents.
Okay.
Yeah.
Okay. So what are, if we could summarize just briefly, what are the mandatory documents that a person should expect when they go to an attorney, because frankly, I've had a lot of conversations over the years. Some attorneys will just do a will. They won't do all the other things.
Right.
And so you sit down, and when you're looking at a person's profile and what they have, and you say, okay, here's your will. Where are your other documents? What would you say is a must?
All right. I'd like to give a little background explanation of that. Any lawyer in Ohio who is licensed by the state of Ohio may write a will.
Okay.
Writing a will is considered the practice of law. So any lawyer may do that. That does not mean that a lawyer is a specialist in estate planning.
Mm-hmm.
There are, maybe 120 of us in Ohio, certified specialists. And that doesn't mean that we are the best estate planning lawyers, but it's more likely that if people go to a certified specialist, that they will get someone who will do the comprehensive documents. So, and I say that because David, my first husband David, and I had lived in Ohio very briefly when he was diagnosed, and we did not have wills, and so I very nervously asked him after he was diagnosed if he minded if we went and got wills. And I wasn't a lawyer then. I knew about the Bar Association, so I called the Dayton Bar Association, got a referral for a lawyer. David and I went to that lawyer. We were in and out of his office in 20 minutes.
20
minutes. Yes. We were sitting on a couch in front of his desk, and he was very pleasant. And he said, well, you know, what do you want? We said, we want wills. Well, what kind of wills do you want? And
I don't know.
Beats us.
A, B,
you know,
who knows?
Do you want a simple? Oh, simple will sounds good. Yeah,
okay.
He got our names, and of course we were very concerned about Amy because she was only 2. We wanted to name guardians for her, and we signed the wills in 2 weeks. And David was dead in 8 months, and I had no power of attorney, which I could have used. Now, this was a long time ago before Ohio had health care directives, but I later found out that that lawyer was a bankruptcy attorney.
And was not an estate planner.
He was an estate planner, but the thing of it is, with many bar associations, maintain lists of lawyers who are willing to do wills, and they pay to get on those lists.
Okay.
So, and then the Bar Association will give out their names. So that's how I got this lawyer's name. He was very nice. I had him handle David's estate. He was very reasonable, thankfully,
yes.
you know, and that worked out well for me. We didn't have complicated planning to do. But as I said, there were some documents that I could have used. So certainly the will, back to answer your question, the will is the foundation document in the estate plan. And at a minimum, the will ought to explain who the beneficiaries of the estate will be, and then who will be in charge. That when there's a will, that person's called the executor. And the Ohio Revised Code's been neutered, so women are executors now too.
Oh, not executrix.
No, and not in Ohio.
Okay.
Yeah.
Okay.
And then for people who have minor or children or are guardians of incompetent children, then we would have a section naming the guardians for those children. First, second, and third choices for guardians and executors.
Okay.
And then, for certain planning situations, people may need a trust. Now, you said, I believe you used the word necessary, and that can be a subjective determination. You know, what I might think would be necessary, the client might not think would be necessary. But Ohio doesn't have an estate tax anymore.
Right.
But the Fed still does. And the federal estate tax exclusion amount this year, indexed for inflation, is $5.45 million.
Okay.
So if a person comes to me with a $10 million estate, my judgment is that a trust would be necessary to address the estate taxes. Then everyone ought to have a general durable power of attorney to address financial decision making. so that bills can be paid, property can be sold, an investment account can be dealt with, that sort
Prior
of thing.
to death.
Prior to death, yes.
Which is where people get really
the
kind
power of
confused.
attorney expires upon death. Everyone ought to have a health care power of attorney enabling, again, first, second, and third choices of people to make health care decisions for them if they cannot make those health care decisions for themselves.
Okay.
Everyone ought to have what we call the rotor form, the right of disposition of remains, which is a document in which a person designates a representative, again, first, second, and third choices, to be in charge of one's funeral and burial.
Now that's rather recent, isn't that?
Actually, I think it's about 8 to 10 years old now. Yeah, I think maybe 10 years old. Why is that so important? Because families don't agree on this situation. They don't agree about funeral and burial arrangements for their loved ones, especially on the issue of cremation. And most of the funeral homes in the Miami Valley will require the consent of the next of kin to cremation. Now, if there's a rotor form, the representative can consent to that.
Okay.
But if there's not, then, and I had this situation, there was a family with 4 children, 4 daughters, and 2 said yes and 2 said no on the cremation, and the funeral home felt like it was stuck. And then the executor got me involved and said, please advocate, this is what mom wanted, cremation. And I said, well, did you show the funeral home, the funeral director, the rotor form? Well, no. So I called the funeral director and I said, there's a rotor form. Oh my gosh, there is.
Right.
Get it to me and that settles it.
And that settles it.
Yeah. So
it's amazing.
we consider that to be an essential document too.
Okay, that is. And continue.
Well, and the good thing, and this goes back to our fees, there are standard forms for the healthcare directives and for the rotor form, and we give those to clients without charging a document preparation fee as long as they complete them themselves, bring them to our office unsigned, and then they sign them in our office.
And what about living wills?
The living will is part of a healthcare directive booklet. Some of our clients decline to do living wills, but many who feel strongly about end-of-life decisions, and especially about that feeding tube decision, want to have a living will. And then also, a document that may be necessary, depending upon one's diagnosis, would be the DNR, the Do Not Resuscitate, for people who have been diagnosed with a terminal illness. They want to die without artificial means. They're going to want to have a DNR form because the emergency medical people who show up when 9/11 is called, they have to resuscitate unless there is a DNR order that can be demonstrated or shown them at that time.
So literally, if the emergency personnel show up and a person's in a coma, they must keep that person alive.
They have to work them.
They have to work them.
That's the nomenclature that I heard the leader of the director of the EMT program at Sinclair use. We either work them or we don't work them. And if they don't have a DNR order that we know of, a bracelet or a form that the family can show them,
they're going to work them.
They're going to work them.
Despite the outcome.
Right, right. And I don't know that I can get the percentage absolutely correct, but I believe it's in the 90 percentile when a person has been without oxygen for just a few minutes, that even if the person's life can be revived, their brain is not functioning anymore.
That is so tragic.
So those are some other documents. That's another document that can be an essential document as well.
I would think so. So the healthcare directive documents, I would say, given the times we're in today, are essential But again,
Absolutely.
you need to be working with a specialist. It's like I tell people, you can go to a general practitioner doctor, but if you have cancer, you better be talking to an oncologist.
Right.
Is that a fair analogy?
Absolutely. You know, I speak to a lot of women's groups, and I say, look, you didn't go to the bone man to deliver your baby.
No, you didn't.
You know? You know?
No, you didn't. No, you didn't. But that is true, and I think a lot of people, again, they don't know.
No.
Because
No.
I've had this brought to me time and time and again, which is, I will not advise you on these matters. This is where you seek the advice of a specialist. And I said there aren't a lot of them, but they are definitely worth every penny.
Yes, we are. Yeah. Now, may I speak to another issue?
Yeah.
A very common misconception is among married people.
Okay.
In Ohio, I can only speak to Ohio residents because I'm licensed only in Ohio, is that if I'm married, I just receive my husband's estate.
Okay.
And unfortunately, that may or may not be true, depending upon the children you share. Now, Ohio law was changed a few years ago, I don't remember how many now, so that if husband and wife share the same children,
Okay.
and husband dies without a will, wife will inherit everything from husband.
Okay.
Okay? But if they don't share the same children, and husband dies without a will, then wife, depending upon how many children there were, if there was one child, let's say he had a child from a prior relationship and they didn't have any children,
Okay.
she will get half and that child will get half.
Okay.
If there were 2 children in the mix, she will get 1/3.
Okay.
And the children will get 2/3.
2/3.
And
That's the one I'm familiar with.
That's the probate of the probate assets. Now, if there are assets that have, you know, for example, if he through his employer had designated her as the beneficiary of his retirement account or life insurance, she will receive those.
Per designation.
Yes.
Yeah.
On the other hand, and I've had this situation where he designated, he had more than one child, he designated one child as who was a minor as the beneficiary, and the mother thought that both those children ought to share, and she just fought tooth and nail over that issue.
However,
But she did not prevail because the beneficiary designation was a contract between him and the insurance company, and that controlled.
now the fact that the child was a minor,
Well, that meant that we had to go to court, and the mother was appointed as the guardian of that money. Now, she was the natural guardian of those children, so we didn't have to have a guardian of the person, but she then was appointed as guardian of the money. And where she got in
without
trouble.
bond.
Oh, no, she had to be bonded.
Okay, I was going to say.
Oh, yeah, she had to be bonded.
Viewers, listen to this. You're going to have to bond. That's
There was no
important.
will.
Yeah.
There was no will that waived bond. So how this case played out, as I said, she believed that both of her daughters should benefit from this life insurance policy, even though only the one had been named. And so she dispersed money from the guardianship to both of her daughters.
No, she didn't.
Oh, yes, she did. And the judge removed her.
And the judge removed her.
Removed her and told her and got the bonding company involved.
Because she had violated.
Right.
Did she understand? Did she really
I don't think she ever got it.
Got it, yeah.
And she was a college-educated woman. But she was adamant that both of her children should share in this money.
But her husband made a decision
Yes.
a priori, and that's it.
Right.
My goodness.
So
Can we speak to an area that I know is big today, and that is the number of females out here that have children single women that have children, and what happens in the event of the mother's demise?
Oh my goodness.
I gotta say it because it's real.
Well, yes, you brought the elephant.
I brought the elephant to the room.
To the room, yes. First of all, under Ohio law, the natural parents have the right to be guardians, or we think of them as of it as having custody, you know, in the domestic relations sense, but in the death-related sense, in the probate court, it's guardianship. And so, let's say mother had, and you know, this is not uncommon, but mother had 3 children from 3 different fathers.
Exactly.
Then those 3 different fathers would get first dibs
On raising
each child.
Okay.
Yes. Now, that father may or may not be appropriate. And so then, if not appropriate, then the war is on.
Wow.
With a court hearing to determine who is the suitable guardian for that. We've addressed that kind of a situation in the context of doing wills. We have a provision, a template that sometimes we put in wills. I call it "Daddy is a rat fink." A template.
It's a rat thing. Very good.
and you know, we're not allowed to really talk about what's really going on with Daddy because we don't want the state to be sued for slander, libel, that sort of thing. But we put the court on notice that he would not be, realizing that he would have, as a natural parent, the right to be guardian. These are the reasons why he should not be, and we speak very generally.
May I bring up a situation, and this is not in this state, of course, but it did happen, and I was privy to it, and that is where the mother had 2 sons, and the father, she divorced the father because he was a pedophile. And she was explicit in her will that the children not ever go to the father. And would you believe she died while they were still children? And the family fought it.
Sure.
Her family, but they did not prevail.
Oh dear.
They did not prevail.
Oh,
the
dear.
Boys were sent to live with their family, with their father, and his family, which operated in an arena of denial, which is she just had a vendetta against him, but she didn't because he had actual charges.
Oh dear.
Yeah, he was in fact that person. And the boys have since, they're now adults, but I've always said in the back of my mind, what could she have done differently to make sure those children did not go to their father? And that's an extreme example, but there are men that are not fit to raise these children.
Right.
And to find themselves as custodian of a child. Is there anything that you can write that rat fink clause in there, but will the judge, will the court understand the context?
I don't know. A couple things that I think of are, there is a process where a person can probate her will while she's still alive.
Oh my goodness.
And it's called, Latin term, ante mortem, A-N-T-E, mortem probate. That may give some weight to her decision to name someone other than the natural father as guardian. But I would say build a record too. Consult with counselors, clergy, people of professional credibility who could provide testimony.
In the event of an adversarial.
Yes. Yes.
That troubled me. It's troubled me
absolutely
for years because, again, that was an extreme case, but I have advised on radio as well as this show that women that have children that are single raising children, that you need to make sure they have life insurance, number one.
Oh, yes.
They must have life insurance, and it's cheap. So get life insurance. And the other thing is make sure your will names guardians who have accepted.
That's right.
Guardians are willing to take care of your children.
Right. Right.
Because if the parents get involved, the question that I always ask is, and one woman related it, how she could not tap into that young lady's money to raise those children without, the court had a trustee that handled the money.
Okay.
The parents did not get to handle the money. They could request disbursements. But it was a very onerous process for all those years. Has that been something you have encountered?
I'm trying to think. Not really, not that kind of a context. Yeah, probably the worst one was the case I mentioned earlier.
Okay.
About the mother spending the money on both of her daughters. Yeah.
And the judge saying, I don't think so, violation of law.
But Michelle, you brought up another issue that really is involved with estate planning.
Okay.
Not just getting a will, but estate planning. You know, when young couples come to us, well, as I said earlier, we send out a packet of information that contains a 21-page checklist to complete. And we ask about assets. What do you own and how you own it? And because David, this is another part of the story, David had insufficient life insurance when he died. I'm sensitive to that issue. And so, especially for young couples, we look at the life insurance that they have and say, either you don't have enough or you might not have enough, depending upon the lifestyle that you want your surviving spouse and children to have. And we give them some forms to use to calculate the sufficiency of their insurance, and then suggest that they go back to their insurance agent if they have one, or if they don't, we make some recommendations. And as you said, life insurance is cheap. And when
you're young, it's cheap.
That's part of the estate plan as well. And then as our clients age, actually, we tell all of our clients this. We tell the youngins, the young couples this. Now, we don't expect you to do this now. You're probably even too young to do this now. But we're telling you this, and I'm using the plural we because there are two other attorneys in our office. But we want you to know, we don't want you to be ignorant. You're going to need long-term care insurance too.
Thank you, please. Thank you for talking on that.
Yeah, and that's basically insurance that will cover the cost of assisted living, home care, nursing home care, if those are necessary. And we tell people to get it, to consider getting it around age 50. And so and some of our clients have done that, and we feel so gratified when they've done that. Some look at me and say, we'll take our chances.
Oh my God, but the statistics say
it's
going to happen.
They do. But there are people who
Okay.
don't want to spend the money, Michelle. They just don't.
Well, you know what, and I say this, we buy car insurance probably because it's the law.
Yeah.
Because there are people that would probably crash you up and wouldn't care. We buy fire insurance, not with the expectation that our houses are going to burn down, but because we want to make sure that if that does happen, that you are covered. We may even be doing flood insurance the way things are going around here. But to ignore long-term care is just inexcusable.
Well, it's irresponsible.
It's so irresponsible. Who do they think, and I'm going to be, viewers, who do you think is going to pay for you in a facility or at home because you're not able to take care of yourself?
Michelle, they think the government's going to pay for that.
The government will if you're poor.
If you're poor.
And you will be poor.
But,
you will be poor when they finish. You will be poor.
Yes. Another misconception is that people think that Medicare will pay for long-term care. They do. Or their private insurance, or here's private health insurance, or here's one that I've had to deal with lately it's a pretty touchy issue, but many veterans believe that the Veterans Administration will pay for their nursing home care.
They think the VA is going to pay for their nursing home care.
They do. The veterans, and I'll say, this is what I understand. Now, what I want you to do, and we tell on that checklist that we have people complete, it asks for their military service history.
Okay.
So if they've given us military service information, we give them information on consulting with a veteran service officer. And we say, go to your county veteran service officer and get informed about your veterans benefits. So these particular veterans who insist that VA will pay for their nursing home, you know, I think they'll, you know, they'll get enlightened when they go. But my understanding is that VA will pay for nursing home care only if the reason for the institutionalization, as we call it, is service connected.
Exactly.
Like my first father-in-law, for example, had dementia that was connected to a brain injury that he sustained in World War II.
Okay.
And so VA paid.
Of course, so there would be liability there.
VA paid for his nursing home care. But let's say, you know, a veteran lost some limbs and is wearing prostheses and that sort of thing, and then gets dementia. I don't know of a causal connection between losing a limb and dementia. I just don't know. I don't think that VA would pay for nursing home care under that situation.
And neither should they, because there has to be some level of accountability and responsibility. Time has run out.
Oh my gosh.
I told you.
Oh my goodness.
We haven't even gotten into this where I wanted to, but as always, it's been a bit, but it's always a pleasure to have you on. And give the viewers your telephone number, how they can reach you, or internet, how they can reach you.
All right. Well, I'm Nancy Roberson, and our office number at Roberson Law is area code 937-643-2000, and our URL for our website is www.daytonattorney.com.
Okay,
Dayton-attorney.com.
Dayton-attorney.com.
Yes.
And if they type your name in, Nancy Roberson,
if you could Google
will send you right where you need to go. And they can always call you. And I'd just like to close out by saying that I personally endorse this woman. I've sent people to call her. I'll continue to refer people to her in Ohio. Can't help you folks in Kentucky and Indiana. I do have some people in those areas, but do not allow your pride and arrogance around something that you know very little about to cost you, because the probate industry is huge, and there's money being made every day at the expense of your family and your heirs. It does not have to be like that. You can get expert help. So again, I appreciate you watching this show, and wherever it's airing, I hope you will give her your serious consideration. There are, just as a caveat, there is Pro Seniors, if you're in Southern Ohio, that will do free legal help based on your income. This is a program that's really geared toward people that are very, very poor and may not have the same resources. But everybody else, just do what you need to do what is right, protect yourself, protect your family, and handle your business, again, by doing business with people such as Nancy Roberson. So I want to close out today's segment, as always, and sharing with you how much I've enjoyed the pleasure of you being a part of my world. I love this work. I love this job. And encouraging you to always keep your families first, keep God before your family, because He's going to be the eternal judge of your stuff. And look forward to seeing you on my next segment. Peace, love, and God bless you. You take care.
God bless you.
Thank you, Nancy.